Hi, this is Liebenau. I am a PhD student at LMU Munich, Germany, and I'm delighted to share with you my PhD research in this video essay for the 40th A-Trip Congress. This is my supervisor, Professor Ansgar Oli, who probably does not need a detailed introduction. He's a professor of IP at LMU Munich and a permanent visiting professor at Oxford. He's also a member of the A-Trip Executive Committee and will chair a panel at this year's Congress. So I came here to Munich via my undergraduate studies in Bayreuth and LM at Harvard Law School, as well as a clerkship with placements in Munich and Tel Aviv. This video essay really is a throwback to my time at Harvard when I audited a course at the Department of Art, Film and Visual Studies. It was a course about horror movies, of all things, and it required students to make a video essay about a movie. In film studies, video essays are a viable alternative to the traditional written essay, and there are peer-reviewed journals dedicated to them. So sorry for the personal narrative and getting meta on the video essay format. It is a natural nexus to talk about film on film, but in law, it depends, I guess. So loosely based on Adorno's famous musings on essays, I see this as an adventurous trial to use video editing software instead of the usual old voice-over PowerPoint in order to gauge how relevant such a format could be for us as lawyers. As I was briefly talking about horror movies, now the scary part, my PhD thesis. It combines doctrinal analysis with some legal theory, and the aim is to conceptualize what it means to over-enforce rights. Now, over-enforcement of rights, especially in copyright, has received a lot of buzz lately. For example, with regard to Article 17 of the DSM directive, it has been argued that internet platforms overblock allegedly, but not really infringing content, and this overblocking leads to so-called chilling effects on fundamental user rights such as freedom of expression. But what does it mean to over-enforce rights? And what are and should be the remedies? And what, if anything, makes IP rights special in that regard? In classical legal thought, whether or not a right exists is simply determined between two parties in a formalized procedure, a lawsuit, by a neutral arbiter, a judge. Rudolf von Jhering famously called this, in the somewhat aggressive rhetoric of the 19th century, the struggle for law. In that view, there is no over-enforcement, just enforcement, because the boundaries of rights are determined ex post by the court. If anything, the classical perspective fears under-enforcement, not over-enforcement, and the question is there enough access to justice? The risk of falsely determining a right is distributed not in substantive law, but rather on the level of court costs. Not every enforcement is respected though. Most jurisdictions have functional equivalence of abuse of right, which either focuses on the malicious intent of the parties or are expressions of an efficiency principle that suboptimal conduct is contrary to public policy and should therefore not be tolerated. To use Hofeld's analytical framework, the right of A corresponds with the duty of B. And if A has no right, then B has the freedom to act. We could play the same game with the lesser-known second-order Hofeldian correlatives opposites, which, in my interpretation, can be understood as either enforcement of first-order rights or derivatives of first-order rights. Can there ever be a situation in which a no right corresponds with a duty, so that the alleged infringer has their own counterclaim instead of just freedom to act? In the Hofeldian framework, this is a logical fallacy and can only be explained with normative intervention. In my PhD thesis, at least for the scope of German law and EU law, which I've analyzed, I found that the courts indeed developed these normative interventions rather than the legislator. And this case law is a source of major legal innovation. New rights and duties were created, and a phenomenon which I call proceduralization. Not respecting the procedural steps of enforcement is the genuine source of the counterclaim, not the objective boundaries of the right. My PhD thesis surveys civil law broadly to find these instances where over-enforcement leads to counterclaims of the alleged infringer, in contrast to those instances where law calibrates the risk of falsely determining a right in the right holder's claim only. It deals with remedies of such counterclaim, injunctions, damages, or merely the costs of legal counsel. It deals not just with IP, but also contracts, property, and torts. For IP, the main examples which I analyze are so-called wrongful threats of IP infringement, which most jurisdictions conceptualize as either a tort or a claim in unfair competition and is mostly limited to patents, and intermediary liability situations where users demand to republish content that has been taken down. The question remains, what makes IP special? I leave this as a little bit of a cliffhanger here, just like in the movies, because after all, I still want you to read my book. But at the core, I think the answer is that IP rights, within a spectrum of the different rights, of course, are archetypes of strong rights, but they are peculiar in one aspect, and that is the incorporation of third-party interests. This is yet another instance where IP enforcement needs fine-tuning. In that sense, my approach relates to those who seek to reframe the public domain not just negatively as the absence of IP rights, but instead as a positively invigorated right. Ultimately, my thesis proposes, I call it a quasi-tort, to solve the existing cases of over-enforcement under a new umbrella. Thank you so much for your interest in my work. Please follow me on Twitter or write an email. Attached, you'll find a bibliography with core works that influence my legal thinking, as well as interdisciplinary works that help me approach the somewhat daunting task of producing this video essay. Thank you so much, and bye!